Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Hey, you guys, good morning. I am so sorry for those of you that were in that other one. I did not realize by the time I went to bed last night that it was set for 7:45 a.m. But some of y'all were over there. So good morning. No, that was a mistake. I fixed it. We're going to be going live at 7:45 tonight to do the defense trial brief. Now, I did actually find, after actually going through all of the papers in all 30-something of these documents, what is considered, I guess, the defense exhibit list. So we're going to add that to tonight's. And then there's also a list of interview transcripts that it's kind of strange the way the document's worded, because it almost looks like it's almost worded like it's states exhibits. My camera is crooked. It almost looks like it's states exhibits because of the title. But then it's like interviews with the Butanti PI that was hired by the defense. So I don't know why the defense's private investigators interviews with like Bethany Funk and like other names I've never heard of. We're seeing some names that I've never seen before. Now, my brain also might not be connecting them to the initials that we've seen, because we have seen quite a few initials. But no, there's been some names. There's been some names that I've never noticed before. So I don't know why it's listed that way, but we're going to be going over that stuff tonight. That's what that one was for. Because at 7:45 every morning until the 26th of October, the 5-minute segments of the 1112 King Road stuff is going to be coming out. I have it all scheduled out. So yeah, that morning live thing should have never happened. I'm so sorry, you guys. I'm so sorry, you guys. And if you missed it, we went over the 28 pages that they had submitted for whatever they were going to actually submit at trial. Their exhibits. We went over that last night. Let me put the banner up real quick. All right. Okay, so 15 pages. Let me make sure this is on here the right way. Oh, it actually didn't do too bad this time. Uh-huh. All right. It should be okay. Okay, so this is like a layout of what they were going to end up doing at trial. I don't know if they talk about like exhibits and things or other things that we can like pull up, but if something comes up in it and we can pull up something to reference it, and then I'll just pull it up while we're going. Okay, 2. The defendant, Bryan Kohberger, and counsel, please take notice that the undersigned, pursuant to the court scheduling order in this case, submits this trial brief in anticipation of trial, which was supposed to begin July 21st, 2025, with jury selection. Yeah, I did find something else in the jury selection information that I'm like, okay. So I'm going to put that with the other one that we did, that we talked about yesterday in the live, when it comes to the touch DNA and, you know, just forget everything you've ever heard ever. Stupidity. Okay. Introduction. In the early morning hours on November 13th, 2022, defendant Bryan C. Kohberger, a PhD student in criminology at Washington State University, drove his car approximately 10 miles from his apartment complex in Pullman, Washington, to the campus of the University of Idaho in Moscow, Idaho. Defendant circled a house near the UI campus at 1122 King Road several times before he parked his car, entered that house, and used a military-style knife to stab to death the following UI students: Ethan Chapin, Kaylee Goncalves, Xana Kernodle, and Maddie Mogen. The change in like how they're listing them is interesting, because we've been basically told that the way that they've been listing them to us so far is like order of death, with it being Maddie, Kaylee, Xana, Ethan. That's how it's pretty much always been, like, from the beginning. So I don't know if this is a reflection of the true order of death, or if they're just like willy-nilly putting names in any order. But I could have sworn that that was like the protocol when it's a situation like this. And it seems that they kind of just like jumble it whenever they want to. For this, defendant is charged with burglary and 4 counts of first-degree murder. The state is seeking the death penalty if defendant is convicted of any of the first-degree murder counts. The trial in this case will tell the story of defendant's crimes and the investigation that led to his arrest. The evidence will prove to the jury not only that defendant is guilty beyond a reasonable doubt of all crimes charged in the indictment, but also that given all of the relevant facts and circumstances, defendant's crimes warrant the death penalty. Yeah, y'all already honestly knew whoever did this, in my brain, deserved the DP. I'm not convinced with who's the person. I'm just not. They've still not shown that piece. That's why we're still here and as deep as we are. Okay, it doesn't make sense. But for the crime itself, oh yeah, no, you don't need to be breathing, whoever you be. I don't even, if magically they can prove and it actually was Kohberger, he deserves it too. And he didn't get that. So that's my opinion. This is a DP situation because you're a sadistic psychopath, whoever and however many. I've been seeing so many disgusting things online. Like if you get on Twitter is really where you'll see all of the horrible news really, 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 really fast. Of all these people who are constantly getting away with things, getting a slap on the wrist. There is such a sadistically sick case out there right now of a 9 and a 10-year-old who did a lot of really effed up things to a 5-year-old child. And we just had another story of like a group of freaking 5th graders who were like contemplating a murder to hire plot. And remember, I brought you a story I don't know, it's been over a year now, of an 8-year-old in Texas that shot a man to death in an RV park. That's just the children. That's what the children are doing now because they're seeing all these adults keep getting like slaps on the wrist and not getting in trouble. There's no examples set anymore. So many people, so many of these thugs, so many of these gangsters, so many of these people that are just dealing drugs and shooting people and doing all kind of crazy shit because they're just doing crazy shit all over the place. Constantly out of jail. What happened in Tennessee? This girl's dad was suing the court because the boyfriend had gotten out of jail so many times for doing horrible things, and then she ended up no longer alive. Then look at that one girl, the Ukrainian girl that was over here that got killed on that bus. That dude had been in and out of jail how many times? I'm sick of people that do sadistic things getting away with it. And you know what? If you have to like the DP a little bit more than maybe you should in order to alleviate that, then I don't know if that's a bad thing because of the way that the world is going. Like it sucks, but maybe like somebody needs to bring some fear back because the world is sick. Like I'm so scared for like what my kids are walking into. No one has any stop anymore, no pause. They see something online that's completely manipulated and fake, and they're like, that's a great idea. Let's do that. It's just really scary. It's really scary. So yeah, this was always to me a DP case because whoever did this didn't deserve to keep breathing amongst the normal people. And that's just my opinion. That's always been my opinion. The elements of these crimes are well established under Idaho law and are presented in the state's requested jury instructions. The state has provided notice of intent to seek the death penalty based on 4 aggravating circumstances. Okay, well, these were the charges. We know what they are. And then the circumstances were, at the time the murder was committed, the defendant also committed another murder. This is the kind of like the stuff that they read out. The murder was especially heinous, atrocious, and cruel. Yes, it was. By the murder or circumstances surrounding its commission, defendant exhibited utter disregard for human life. Utter disregard was definitely a situation. Defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. See, that right there. How many people get out after killing people? How many of them, like, do something crazy and a life gets taken and they get, like, 5 years probation? Okay. Why can't it instantly be, if you do it once, you're gonna do it again? Why is the saying once a cheater, always a cheater, and not once a murderer, always a murderer? Why isn't that like a thing across the board? I hate it. I hate it here. The state's requested jury instructions also cover the penalty phase. All right. The state's case in chief. Opening statement. As detailed below, the state's case in chief will involve presenting significant amounts of evidence over the course of many weeks, if not months. Holy shit. Were they really expecting the case to go on to trial for months? I mean, it was 28 pages, but it was a lot of photos of nothing. Like, we don't need a bunch of pictures of the way that the house looks unless there's blood in the picture, unless it's telling a story about what happened. And it just felt like they were trying to bombard the jury with all kinds of stuff just to make it fill up their heads with a bunch of nonsense and make it almost like difficult. It's just what it seems like. This just, again, it seems to be the theme of how this case has gone this whole time. Months, that's insane. During opening statements, the state intends to show the jury certain selected exhibits and certain jury instructions to facilitate the state's overview of the evidence. Pursuant to the court's redacted order governing further criminal proceedings and notice of trial setting dated October 9th, 2024, herein the scheduling order. The parties are required to file a log of objections to exhibits by May 14th, 2025. Yeah, remember, all this stuff is like older. When was this one? I think this is an April document. April 14th, 2025. Okay. Accordingly, the state should know whether defendant objects to the exhibits it intends to show during its opening statement and will alert the court through motions in limine or other mechanism preferred by the court of potential disputes so that the court can have the opportunity to resolve them prior to trial. Witness testimony. If you guys didn't see, I found where Cy Ray was still listed as a trial witness. I posted it in the community tab yesterday. So, I mean, I know that we haven't really heard from him at all, and we haven't heard anything from him since he was called a conspiracy theorist in court. And there was a lot of rumors before that he was no longer going to be part of the case. But again, like the documents and now his class, the label of his class is just real interesting to me. And again, that's just my opinion, but we just found more proof that he was still part of the case. Witness testimony. The state is currently finalizing its witness list and will be as inclusive as possible to ensure that it is prepared to establish proper foundation for all testimony and exhibits. The state may not need to call all of the witnesses on the forthcoming witness list as it learns of defendants' evidentiary objections, and the court has the opportunity to resolve any disputes. Categories of witnesses. The state's witnesses generally can be organized into the following categories: roommates, friends, acquaintances, and contacts of murder victims. The state intends to call members of the University of Idaho and Moscow community who knew or had contact with the murder victims at relevant times, including on the night of the murders. Such witnesses will include the victims' surviving roommates who are victims of defendant's burglary offense and friends who responded to the house around noon on November 13th, 2022. The state will also call other individuals who had contact with the victims on the preceding days up to the night of the murders to establish the timeline of events. You can't even give us a timeline of events. What do you mean you were going to establish one in court? No, you weren't. You still can't tell us what time Xana and Ethan got home. Ooh, this stuff's going to make me mad. The lies, the gaslighting, it's insane. Law enforcement officers and investigators. The state will call law enforcement officers who first responded to 1122 King Road. The state will also call investigators who were responsible for and participated in the extensive investigation that led to the charges in this case. You mean all the feds? Because nobody in MPD had heard of him until the feds called y'all. There was not even any tips about Kohberger that they went back to look for. There was nothing. So you must be saying you're going to call all the feds then. These witnesses will include officers and detectives with the Moscow Police Department, investigators with the Idaho State Police, agents with the Federal Bureau of Investigation, and law enforcement officers who had contact with defendant at relevant times, including upon his arrest in Pennsylvania. What about Homeland Security? They helped. They helped with stuff in Idaho. I don't see them on here. Forensic analysts and experts. The state will call law enforcement specialists who collectively conducted the forensic investigations in this case. These include those who possess specialized knowledge, skills, experience, training, and education in the following fields: electronic device review and data extraction, cellular data analytics, DNA testing and analysis, and financial records forensics. These witnesses are primarily employed by MPD, ISP, or the FBI. To the extent necessary, the state previously disclosed these witnesses through its expert witness disclosure. I think it's Michael Douglas is the financial dude. Family members of the defendant. The state intends to call family members of defendant for the purpose of establishing certain facts before defendant moved to Pullman in late summer of 2022. Okay, so then let's just go ahead and on live debunk the boo-boo of mainstream media. Because what have they been out here claiming? Oh my God, just days after Kohberger's sister was added to the state's witness list, he pled guilty. This is an April doc that specifically says the family members are going to be called. So even if they didn't know for the past freaking 2.5 years, 3 years, that the family was going to be called by the state for some reason or not, which they did, come on now. They knew in April. He didn't plea in April. So this document right here debunks the damn sensationalist bullshit that Brian Enton and News Nation and all of them have been spewing. It's just so stupid. They just try to use everything. It's so dumb. It's so stupid. Okay. Certain facts before defendant moved to Pullman in late summer of 2022, as well as facts about defendant's conduct when he returned home to Pennsylvania in December of 2022. The nature of this testimony has been disclosed through reports of interviews. Foundational witnesses. The state will be prepared to call all witnesses necessary to authenticate the exhibits it will introduce at trial. This will include calling witnesses who can attest to the chain of custody for physical exhibits and those who can establish that certain documents are business records and therefore not subject to exclusion or hearsay. That was a lot of the issue with the self-authenticating records. That's why we constantly saw like the additional paperwork at the end signed by people at the companies. Depending on any objections that defendant makes to the state's exhibits, the state may raise authentication and or foundation disputes with the court in an attempt to streamline the number of necessary foundational witnesses. Considerations and requests regarding individual witnesses. Privacy for testifying victim witnesses. The state will call 2 roommates of the murder victims who were present in the 1122 King Road house during the murders. These witnesses were 19 years old at the time of the murders. They have been understandably traumatized by what transpired and are victims of the burglary offense. They have received death threats, have been the subject of conspiracy theories, and have been harassed online in ways that continue to affect their privacy, interest, and well-being. Dylan Sir seems to party it up just fine. Come on now. Quit gaslighting everybody. Like, seriously. Seriously. The state is concerned that if video of the witness's testimony is broadcast on the live stream, individuals outside of court could screen capture images of them and circulate them on the internet in harmful ways. These are adults that failed. And then what ended up happening at the end? Dylan got up there and on cue, I can't breathe. Okay. Miss me with the bullshit. I don't give a damn. Accordingly, the state's request that the court pause the video live stream, but not the audio, if possible, during the testimony of these victim witnesses to protect their privacy to the extent possible. Yeah, we already knew that was going to maybe be a possibility, where they were going to try to shut off the camera and not let us see their faces while they testified. It's just so ignorant. We know who the frick you are. The only reason why you wouldn't want us to see your face is because you don't want us to catch you lying or not like acting like you should. Or telling the truth. No. You're a grown-ass adult. You're out there doing grown-ass things, signing leases, having boyfriends, doing nasty stuff. You a grown-ass adult. No. You got a tattoo? 19 at the time. Got a tattoo just like that? Okay. I don't want to care. I don't care. That's an adult thing. I don't give a shit. I don't give a shit. The protection for these two whenever they straight up lie to the police from day one is disgusting. The court should grant the state's request pursuant to Idaho Court Administrative Rule 32 and Rule 611A of the Idaho Rules of Evidence. The former grants courts the discretion to adopt trial procedures that provide public access to court proceeding while minimizing the risk of injury to individuals and protecting individual rights, privacy rights, and interests. Rule 611A provides the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth, avoid wasting time. So resetting all the cameras and having to reset the way the whole live stream is happening isn't a waste of time. Come on, this is dumb. Protect witnesses from harassment or undue embarrassment. We were going to hear what they were going to say anyway. We were going to hear it anyway. Dumb. As an initial matter, the state's request does not prevent public access to the witness's testimony. The public will be able to hear their testimony. Exactly. We were going to freaking dissect what the frick they said anyway. It wouldn't have mattered. The members of the public who are present in the courtroom will be able to see the witnesses as they testify. This is consistent with the vast majority of trials in the state of Idaho, which are not live streamed. Effectively, the state's request simply prevents the images of the witnesses from being re-recorded and disseminated in potentially harmful ways. God, the fact that we know how much of a lie their story is This is just the most ridiculous thing to read. Like, we knew that this was how it was going to be. We already heard them talk about it in court. But going back in and like, now that we freaking have even more proof of things as the evidence is coming out of the lies that were told. How can so many thousands of people see these things, question these things, because it's right there in our faces in black and white, and the state wants to sit there and gaslight everything that we're literally seeing in front of our face? It is insane. I mean, it's just wow. It's mass hysteria. It's insane. The witnesses' voices and the content of their testimony will still be available on the live stream. As such, the state's request presents the least restrictive exception from disclosure and is consistent with the policies underlying Rule 32. And there's a time thing. A footnote. As applied to sealing or redacting of court records, Rule 32 contemplates a motion and a finding by a court. The state stands ready to make a formal motion if the court prefers. Blah, blah, blah. Okay. Ridiculous. Support for victims, and young witnesses. Several witnesses, namely the surviving roommates and other friends of the victims, are young people whose lives have been upended by the trauma of the murders and the aftermath caused by the intense media attention on this case. They're doing interviews. They're talking about the case. So it can't be too traumatic for them if they're out here actually speaking about it on camera. I mean, I get it. Their friends died. It's got to suck. But when you're out here in the public already, you can't sit here and expect me to be okay with the court wanting to coddle you. I'm sorry, but no. Some are represented by counsel, and most have family members who intend to attend the trial to support them when they testify. Anticipating that courtroom seating may be scarce, the state asks that the court allow for counsel and family members of these witnesses to be seated in the courtroom when the witnesses testify. The state will provide advance notice to the court and its staff. Okay, well, you should just reserve seats, slap names on the seats. Lead case investigators at the counsel table. The state is designating Moscow Police Department Corporal Brett Payne and ISP Sergeant Darren Gilbertson as its advisory witnesses. Now, I'm going to do a separate video on this very specific thing because it's more of Brett Payne bullshit. This again is an April document. When did the families get the email about Brett Payne no longer working for MPD and going into a non-law enforcement position at the U of I, but being deputized in as a prosecution's investigator? April. Because I was told like May 8th or 2nd or something like that. So this is already where they've already been like, create the narrative. Create the narrative that you two sides can sleep with that night and pick somebody to tell the lie. And it was Brett Payne. This is what the email that I got from Kara meant. This is why even after he was the one at the prosecution table, he was the one who did the Q&A after the sentencing with Gilbertson. They created a position to make it still legal for him to be in the courtroom and testify, even though he was no longer working for Moscow PD. They literally created it for this case specifically. And here's the proof right here. Pursuant to a stipulation, the parties agree that these investigators may be present in the courtroom during all witness testimony. Accordingly, the state intends for these investigators to be present at counsel table to advise the prosecutors and assist in trial logistics. Segmented testimony by investigators and witnesses. The state intends to present the testimony of investigators and other witnesses in segments to assist the state in presenting its chosen narrative of the evidence. Its chosen narrative? See, true evidence and truth tells its own narrative. It doesn't have to have one picked for it. I don't like this wording. This will also assist the jury in understanding the progression of the investigation at issue. Pursuant to Idaho Rule of Evidence 611A, the court should allow this procedure to make the interrogation and presentation of witnesses effective for the discernment of the truth. There will be no prejudice to defendant because each time one of these witnesses testifies, they will be subject to cross-examination at that time on the subjects covered on the portion of their testimony just presented. Certain witnesses may also be called out of order to accommodate travel schedules or to allow them to subsequently be present in the courtroom after their testimony. Okay. Exchange of witness schedule. The parties are discussing a procedure by which the state would notify defendant as to the anticipated timing and the order of witnesses it intends to call as the state presents its case in chief. The state is willing to work with defendant in this way, but will request that the same procedure apply during defendant's case. So they want like an itemized schedule, I guess. I guess that's probably something you could figure out based on the questions that you planned on asking. Okay. Exhibits to be introduced. And again, we went over that 28 pages. 28 pages last night. The state okay. The state is currently finalizing its exhibit list and will be as inclusive as possible to ensure that it meets its burden of proof as to each element of each charged offense. The state may not need to introduce all exhibits on the forthcoming exhibit list as it learns of defendant's evidentiary objections, and the court has the opportunity to resolve any disputes. Categories of exhibits. The state's exhibits generally can be organized into the following categories. I forgot to do this. I usually give you all the document. Here's this one. There you go. Okay. Okay. Physical items. The state will introduce physical items obtained throughout the investigation, including but not limited to items taken from 1122 King Road, defendant's apartment in Washington, defendant's parents' residence in Pennsylvania, and evidence gathered from defendant upon his arrest. There was like nothing of importance, though. Like they've already told us that there wasn't anything in his parents' house, nothing at his apartment, nothing at his office. So what were they going to present after we were already told that? Again, a bunch of nothing just to like murk it up, overload it, unnecessary stuff. The state also will be prepared to introduce as necessary physical samples that were tested by the law enforcement forensic laboratories. Let me check that real quick. Because I don't know, they might drop something on a Saturday. No. Same 4 files. Still waiting for ISP to drop their stuff. Photographs, maps, and diagrams. The state will introduce photographs of 1, the initial crime scene and related searches of the crime scene. 2, the victim's autopsies. 3, the search of defendant's residence in Pullman. 4, the search of defendant's parents' residence in Pennsylvania. I thought they said they didn't have cameras of anything. But notice it also doesn't say arrest. So are they going to try to tell us that they didn't have their body cams on during the actual like breaking in of the doors and going in all, you know, Rambo style to get him, but as soon as he had cuffs on, they turned their cameras on to search it? Nah, quit the gaslighting, bro. Come on now. In search of defendant's vehicle in person. The state will also introduce maps generated from satellite images to show relevant locations and defendant's path of travel at relevant times. The state will also introduce diagrams of the 1122 King Road house and the crime scene. Audio video files. The state will introduce the audio of the 911 telephone call that alerted authorities to the crime scene. In addition, the state will introduce 1, body camera footage for law enforcement officers responding to the scene. 2, body camera footage of a traffic stop of defendant several months prior to the night of the murders, which is literally, again, for nothing but identification purposes, regardless of Judge Hippler, for some unknown ass reason, stepping over the freaking line and putting some damn lie in an order document. The state already came out and said no. It was to show his address, his name, his phone number, and the make and model of his car. Nothing else. No premeditation, no planning, none of the bullshit that Hippler tried to put in there. I don't know how he was allowed to come in there and put something else on the evidence that was already not just spoken about by the state, but the document was already filed and said A, B, C, D. And for what I just said, identification purposes only, nothing else, nothing else. So, and again, the only thing bad about that video is the cop lying and not being honest in his own right, in his own shit. I mean, the video literally shows Bryan Kohberger being honest about not wearing his seatbelt when the cop didn't see him wearing a seatbelt, like didn't even notice if he was or wasn't. It looks bad on the cop, not him. So what was the point? What was the point? Okay, surveillance of a white sedan around the area of the crime scene and path of travel following the murders. The state may elect to introduce only portions of the video files for purposes of efficiency. Efficiency? Cherry picking is efficient? Okay. Background records. The state will introduce various records to establish evidentiary facts such as identity, residency, education, and other background characteristics for defendant and victims. Forensic data. The state will introduce data generated by law enforcement forensic analysts who processed evidence in the scene. Such exhibits will be used as foundation for these witnesses' testimony as to their findings. Summary exhibits. The state will introduce summaries of voluminous evidence, financial records, phone records, which are admissible under Rule 1006 of the Idaho Rule of Evidence. Yeah, oh my God, I can't even say the word. Voluminous. A lot of unnecessary things that don't show anything. I don't know why they're allowed to just like actually put a bunch of trash in their evidence. It doesn't make sense. Considerations and requests regarding specific exhibits. In-life photos of victims. The state intends to introduce one photograph of each of the deceased victims in this case while they are still living. In-life photos. To prove the obvious but necessary fact that they were human beings. We don't need to be reminded of that. We're very aware of that. They were beautiful. They were happy. They were going places. They had a plan. We're very aware of what was taken away. We're not stupid. And nobody sitting in that courtroom needs to be reminded of that either. Like, I get it. You're supposed to show the pictures. But the fact that they're like, it's necessary so that we know that this is a real situation. I'm sorry. If somebody has forgotten that, then that's their issue. And again, the people sitting in that courtroom don't need reminders. They're the people that are there because they've got a piece of them missing. They know why they're there. They know what these people were. I'm pretty sure they could have like labeled that differently. Okay. In State versus Garcia from Idaho in 2019, the Idaho Supreme Court ruled that the trial court did not abuse its discretion by permitting the state to introduce in-life photographs of a murder victim because the photographs were relevant to prove that the victim was a human being and to establish identity. It did not matter that the evidence was not disputed. It was still material and relevant. The state is cognizant, however, of the Garcia's court finding that the prosecution in its case in chief presented testimony that went beyond relevant background information and called for a witness to describe the positive attributes of the victim. During the guilt phase, the state will endeavor to quickly introduce background facts about the deceased victims, including the in-life photos, without eliciting opinions about them. I mean, yeah. I agree with that, like who they were, all that kind of stuff. It should be talked about regardless. Like, it should just be a thing that's discussed. But to say that it's needed so that people are reminded that they were human, like, we know that. That's why we're here. That's why we're freaking here, okay? Physical items. The state will present various physical items as exhibits, including items from the crime scene, items seized from defendant, and items that were the basis for forensic examination, like electronic devices and swabs and samples of biological material that were tested. To expedite the trial, the state intends to use photographs of these physical items as much as possible, subject to the court's ruling on any objections from defendant as to authenticity, chain of custody, or foundation. So pictures of the stuff. Well, I mean, I guess you wouldn't want to just like bring a bunch of biological swabs just all over the place. So yeah, I guess so. The state will endeavor to raise such issues with the court in advance of trial after it receives defendant's objections to the exhibit list. Graphic photographs. The state necessarily will have to show graphic and disturbing images of the crime scene and of the deceased victims' bodies. The state will be selective in doing so and will not present unduly cumulative exhibits. Okay, I get it, but when we're hearing that they're sitting there throwing a whole bunch of unnecessary bullshit into the trial, and the one thing that we've seen so far that really tells a true story and gives you a true understanding about what happened that night is the victim's wounds, and they're like, oh, we're not going to show you everything. That's the closest to the truth that we're going to see. So they want to throw a bunch of unnecessary stuff in there that doesn't show blood spatter. It doesn't give direction. It doesn't give any evidentiary value. It has no substance to it. It's just a picture of the floor
There's no blood on it. It's just, oh, this is where the hallway goes. You've got the 3D house for all of that. You're putting so much bullshit in it. But when it comes to the storytelling facts, you don't want to put all of it there. I understand that it's sensitive information. But again, that tells the truth. That tells the story. Everything about this whole thing is so freaking back-ass words. I don't even understand. Thank you for the 5 gifted memberships, RV. Thank you so much. I appreciate that. Congratulations to you guys who got those. Don't forget that our members only live for October is going to be October 27th. I still got to put a little thingy up. I will do that. I will put a thing up really soon here. I have it written down right there. Okay. Okay. Prior to calling a witness through which graphic photographs will be introduced, the state will provide advanced warning to the court and to the families of the deceased victims so that family members can decide whether to leave the courtroom. Yeah, I'm sure some of them don't want to just like sit there and watch all that. I get it. I mean, I would have to, but I get it. The state also requests that the court pause the video of the live stream and turn off the public courtroom monitors when graphic exhibits are published to the jury. I understand that too. You don't need to be live streaming stuff like that. That stuff can be. I honestly don't need to see it. Like, I understand that it's described, and we're getting from just the descriptions enough that we've been lied to. I personally don't want those images in my head. I don't. I want the descriptions. I want to read the reports. I want to put it in my brain the way that I know I safely can. I don't want to see it. I don't want to see Kaylee like that. I want to see her the way she looks, constantly smiling all the time with her beautiful face. I don't want to see what was left. That's not her. I don't want to see that. So I agree. Turn off the cameras. Turn off the cameras for that. I totally would agree with that. 19 months. That's so long, Carrie. Thank you for being here. Thank you for caring about the documents. Thank you for caring about the documents, Carrie. Oh, and 5 gifted memberships. Thank you, thank you, thank you. And congratulations to those who get those. Yeah, I've seen that they've been pulling more bodies out of Houston. Oh, yeah, I'm keeping track. I'm keeping track. I want to start from the beginning of this year, though, is like that was my goal with Houston, with everything going on in Houston, was to try to do at least like maybe one video a week of a few at a time of the people that have been found in there until we get to current. Because I think they're on number like 17, maybe 18 now. I know that I've been seeing a lot. I know I've been seeing a lot of stuff about Houston. Yeah, I just want the truth. I just want the truth. That's what everybody should want. That's what everybody should want. Okay. Okay. Again, as with the testimony of the surviving housemates, the state is concerned that individuals could capture these images and distribute them in harmful ways. Yeah, or put them behind a paywall, like, Zab Girl's sick freak self. Yeah, we haven't forgotten that. The court has the discretion to grant this request under Idaho Court Administrative Rule 32A5 and 6 or -6. The state understands at least one court has adopted a similar procedure in another capital case that was live streamed. This is true. Self-authenticating records. Those were fun to go through. Many of the state's exhibits are self-authenticating records. Oh, well, thank you for the 10, Carrie. That's very sweet. Thank you so much. I appreciate that. Thank you. Thank you so much. Okay. Many of the state's exhibits are self-authenticating records. Where applicable, the state is gathering records, certifications to support the admission of these exhibits pursuant to Rule 902 of the Idaho Rules of Evidence and will disclose these certifications to defendant. To the extent that defendant still lodges objections to these exhibits based on authentication or foundation, the state will seek to raise them with the court prior to trial to avoid using trial time to resolve such disputes. Demonstrative exhibits, meaning the most expensive dollhouse on the planet. The state, well, probably not on the planet. I know some people with money overseas spoil their children in ways that we cannot even fathom. So let's just say the most expensive dollhouse probably in the United States. We'll just keep it there. The state anticipates some of its witnesses will use demonstrative exhibits to assist the jury in understanding their testimony and the evidence. The state understands that demonstrative exhibits do not need to be disclosed as part of the exhibit list, but at the court's discretion will be prepared to disclose demonstrative aids before they are used by a witness. Accordingly, the state asks the defendant also disclose any demonstrative aids prior to their use in cross-examination or by defense witness. Okay, yeah, it's just a stupid house though. Foundation for cross-examination. At the motion hearing on April 9th, 2025, the court alluded to the need for counsel to have a proper foundation for questions asked on cross-examination. The state will be prepared to object on this basis if defendant's attorneys ask improper questions and provides the following case law as support. What do you consider an improper question? State versus Coffer from 1952 in Ohio. Ruling that the district court did not abuse its discretion in precluding cross-examination questions where a witness is so questioned without any basis for the inferences in counsel's questions. Okay. State versus Buck, Idaho, 2023. But this is an unpublished thing that they're citing here. Finding in a murder case that the trial court did not err in precluding defense counsel from cross-examining witnesses about unsubstantiated theories of an alternate perpetrator. Yeah, that part. Yeah. Like basically whoever was in the alt perp doc, once they're on the stand, the state's not allowed to acknowledge the fact that they were an alt perp. That would be an inappropriate question, I guess, to ask about that kind of stuff. State versus Harvey, Idaho, 2006, upholding district court decisions to preclude cross-examination on a topic without an adequate offer of proof by defendant's counsel. And then State versus Nab, Idaho, 1987, finding no error where district court sustained objection to question on cross-examination where nothing was offered to show a good faith basis for the question or that the inquiry was more than a fishing expedition. I sure like to use that phrase. Penalty phase. Defendant disclosed 6 penalty phase experts on March 31st, 2025, with over 200 pages of reports and exhibits. On April 2nd, 2025, the state filed a request for a defendant to supplement this disclosure. Defense counsel is in the process of doing so. Additionally, on April 8th, 2025, defendant made additional mitigation disclosures that may be relevant to anticipated expert testimony regarding defendant's mental condition. Now, remember, Santa was asked, is Bryan Kohberger a psychopath? No. The testing says no. And I think that's what they were hoping for. I think that's what they were hoping for. The state is still digesting these disclosures, determining what expert it needs to consult with, and is in the process of deciding what type of rebuttal expert testimony it will seek to present. The state does not intend to proceed with its own mental examination of defendant and will file a motion for a mental condition examination pursuant to Idaho Code. Does intend. Yeah. Idaho Code 18207. In my brain, I heard myself say does not intend. And then my brain went to, but we've seen it already. Okay. So I'm glad I went back and looked. The state may also need to seek from the court an extension to provide expert disclosures so that its experts can review defendant's disclosure and conduct needed evaluations of the defendant. The state appreciates the opportunity to raise the foregoing considerations with the court. It stands ready to address any questions that the court may have and to assist with any procedures the court would like to implement to ensure an efficient and fair trial that protects defendants' rights, the rights of the victim's witnesses, and the families of the deceased victims, the rights of the public and press, and the interests of the people of Latah County and the state of Idaho in achieving justice in this case. Yeah, okay. Yeah, okay. Y'all have a great rest of your afternoon. I will be back later. I'm going to go ahead and roll this out real quick. Please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. All right, you guys. See y'all.